to finish up on engaging me to be your attorney, if you come in at least 2 days before that scheduled court date on your collection lawsuit, and you hire me to be your bankruptcy attorney, you're not going to have to go to court for the collection lawsuit. I'll handle that, and it will spare you the loss of employment or whatever else you've got to address in taking care of that court date. Let's go on to the next one on collection measures. If the plaintiff gets a judgment against you, what's really the practical impact of that? Well, first of all, if you own real estate, if you own a home or any other real estate, then the judgment is like a mortgage on your property. If they have a judgment on a credit card and it becomes what's known as a final judgment, which down below I show you, an average, a judgment entered by the judge will become final 30 days after the judge signs off on it. Well, if it's a final judgment, that's just like a mortgage on your house. So that if and when you later go to sell your home, you're not going to get the money will be paid to the credit card company to pay off that mortgage. That's called a judgment lien. Now, in bankruptcy, if you file a Chapter 7 or Chapter 13, in almost all cases, that judgment lien, that credit card judgment, is going to be canceled. So that's a real positive benefit about a bankruptcy. If you watch the videos, you'll understand that. Garnishment of your wages. After a judgment becomes final, they can start grabbing your wages. Now, they can take 25% of your wages, or if you're a head of household, they're limited to 10%. Well, who's a head of household? Well, if you've got children at home, you're unquestionably a head of household. But unfortunately, a lot of people don't recognize that there are other situations, relationships, that also qualify for a head of household. Let's say you are supporting your girlfriend and her children. Then you're a head of household. There are all kinds of other situations where even though you're not married, you're a head of household. So if that's the case, then you need to make inquiry. Now, you'll have to fill out a form with your employer, letting your employer know that you're claiming that head of household exemption. That's real important. Now, the third choice that creditor attorneys have is they can attach your bank account. Well, if they do that, they're not limited to 10% or 25%. They'll attach everything in that account up to the amount that you owe them, including accrued interest. So if you have a judgment against you, for goodness sake, don't be putting your money in a bank account, because they can grab that. The fourth alternative that frequently debtor attorneys will do is they'll have the judge, you'll have to go to court, and the judge will put you under oath, and then the debtor attorney or plaintiff attorney can say, okay, under oath, tell me all your assets and where they're located, so that he can grab them and pay that judgment. Well, you don't want to go through all that. Bankruptcy stops all of that. There's no reason for any of that. If you have a judgment against you, then don't put up with that. Now, let me cover some things that come up all the time. Let's say that all the money in your bank account is because of your Social Security payments that you receive. Well, those are exempt from attachment. And if that's the case, you'll have to file what's called a motion to quash, Q-U-A-S-H, and cancel that garnishment. Yes, you get your money back, but it's a pain in the neck. As long as you have a judgment against you, they're always going to be hassling you. So bankruptcy stops all of that completely. The last thing I want to cover with you, and I want to get into it in the next video and spend some time with you, is where not to go for assistance. You know, you've been sued and you don't know what to do, and sometimes when people are under stress, they make some serious mistakes. I don't want you to make those. So get on to the next video. Thank you.